Welcome, everyone. I think we'll get started. Thank you for being here today. I'm Bill Jonason. I'm in the corporate group here at Dorsey and one of the co-chairs, the M&A group. And we welcome everyone that is here live in Minneapolis. And then we think we have about 120 or so attending by webinar. So thank you to all of those attending on the webinar as well. A couple of housekeeping details. Remember, there's an attendance sheet, green sheet here that you should sign in to get your CLE credit. The panelists will hang around for a while at the end of the program if you have any questions, and there's also the opportunity to submit questions for later follow-up by the panelists at dorseyu@dorsey.com. And it's my pleasure to introduce Rachel Benedict, who's going to moderate this program today. Rachel's in the corporate group and M&A group with me. She's been with us for about 6 years now and is one of our stars in the M&A group. And so we're happy to have her moderating this panel and asking our esteemed colleagues some questions about HSR and antitrust. And I'm getting really good at spelling HSR, and I got a preview of the slides, and they like to use acronyms. We've got FTC, DOJ, UPE, ET. For the corporate lawyers, they snuck in LOI and MOU, and of course, one of the companies they referenced is AT&T, so you're going to get a lot of acronyms today. And with that, I'm going to turn it over to Rachel, and Rachel is going to introduce the panel.
Thanks for the introduction, Bill. As Bill mentioned, our program will cover the basics of the HSR process and some recent developments. This is geared towards transactional lawyers who, like myself, run into HSR issues from time to time. And in the course of my practice, I've had the chance to work with each member of our panel today and on different transactions, and they bring a very diverse background for us. So let me go ahead and introduce them. I'll start at the end. James Nichols is a member of our commercial litigation practice group. And in addition to advising on antitrust matters and M&A transactions, James has extensive experience representing American Indian tribal governments and enterprises on healthcare, tax, economic development, and governance matters. And James is also an enrolled member of the Chickasaw tribe. In the middle, we have Erik Ruda. He's a member of our health litigation practice group, and in addition to working in the healthcare space and on antitrust matters and M&A transactions, Erik's also litigated and counseled on franchise and dealer terminations. And he's also co-authored an article on no poaching agreements in franchise industry. And then next to me here we have Michael Lindsay, who's co-chair of our commercial litigation practice group. He's practiced antitrust law for 3 decades, including litigation, counseling, and M&A transactions. He's worked in a very wide range of industries, including fantasy football, tuxedo rentals, agricultural cooperatives, pacemakers and defibrillators, garbage hauling, frozen pies, home security systems, refineries, automotive brakes, hospital services, and we could go on. Our format today is pretty simple. I'm, like many of you in the room and on the phone, I'm a transactional lawyer, and over the years, I've had to ask a number of questions of our panelists as matters come up. But today we have the advantage of going through all of them at one time with our panelists as a captive audience for us. And with that, I'll kick it off with a question that will give us some helpful context. Erik, what is HSR?
And how do you spell it?
And how do you spell it?
Starting off with the important stuff first. Thank you, Rachel. HSR stands for Hart-Scott-Rodino. Not very creatively. It's named after the chief legislative sponsors. But perhaps on the positive side, it's not one of the more creative and infamous acronyms that you see in federal legislation. Basically, the HSR Act is the United States merger control law. Parties to certain acquisitions need to notify the FTC and DOJ in advance and then observe a waiting period before closing on those transactions. Rachel, as you know, and as many of you here today know, many countries around the world have their own merger control laws. In fact, an increasing number of them have adopted them. Today, we're just focused on the HSR Act, but we can and do advise clients on navigating the merger control requirements in other jurisdictions.
So when most transactional lawyers think of HSR reporting requirements, we think about them being triggered based on certain dollar thresholds. James, can you give us some of the rules of thumb that we should work with when considering whether a potential transaction is reportable?
Oh, that's right. And 90 million is the magic number, at least until February of 2020. HSR reportability is based on a size of transaction threshold, and so if you get above 90 million, then you need to start thinking about the potential for a reporting obligation. We'll get into some more details in the succeeding slides on how that plays out. But if you're below 90 million, there's no reporting obligation. Above 90 million, you've got a potential obligation. The 90 million looks at the value of what's being acquired. So in an acquisition of voting securities or LLC interests, that value is going to be the purchase price, or if it has been determined and is greater than the purchase price, the fair market value of the securities or interests. It works a little bit differently for assets. In that case, the value is the purchase price, but you also have to take into account any assumed debt. With voting securities, assumed debt is a subtraction from the size of transaction, but with assets, you need to add that into the size. The size of transaction, the value includes non-compete payments to individuals, milestone payments, and earn-out payments. So you really need to be thinking about what's the maximum possible value of the transaction when you're thinking about whether or not you're brushing up against this $90 million threshold. And so, if there are questions, that's something to reach out to us on. If you're at 90 million, if you're close, if you think you might get there under some conceivable method of calculating the transaction value, do give us a call because you could have an obligation.
So, James, would it be correct to infer from this that if non-voting securities are being acquired, the purchase price attributable to those securities should be disregarded for this purpose?
Now, Michael may correct me if I'm wrong on this one. But that's not entirely correct. That we look at the entire size of the transaction.
Although it does indeed depend, because if the transaction is a mix of voting securities and currently non-voting securities, the acquisition of the non-voting securities is exempt, but the conversion of those voting securities later on is a potentially reportable event, and that's one, as we'll see, does end up trapping people.
So, Michael, then, is any deal with a transaction value greater than 90 million automatically reportable?
No, and there are a few reasons for that. First, as James mentioned, the 90 million calculation for voting securities, you would look at what is the price that I am paying for the voting securities, and if part of the consideration for that is going to be used to pay off debt at closing, then you would subtract that from the 90 million. So that's one way, even though the nominal value of the transaction might look like it's more than 90 million, it isn't reportable because of that particular trick. The other point is that unless it's a really big transaction, you also still look at the size of the persons, that is the ultimate parents of the parties to the transaction. And what that requires is that on one side of the transaction, you have a person who is an $18 million person, and on the other side of the transaction, someone who is a $180 million person. And that's determined by their annual net sales based on their most recent annual income statement, and their total assets as determined by their most recent regularly prepared balance sheet. And it's always important to remember that that most recent regularly prepared balance sheet is the one that's going to exist right before closing. And sometimes that can change. We've monitored transactions to make sure that we know where it's headed, because that can end up converting a non-reportable transaction into a reportable one, or vice versa. Then there's also a range of exemptions for entire categories of acquisitions. And the reason for that is that the HSR Act, these size numbers are completely arbitrary. They started at $50 million back in around 2002 or 3, and that's been indexed annually since then. We're now at 90 million. But clearly not every transaction that meets these arbitrary size tests is going to have competitive significance. And so there's a number of exemptions that they're carved out areas where there just is unlikely to be a competitive issue.
So, James, could you walk us through what some of those exemptions are?
Sure. Some of the exemptions are pretty simple and straightforward. Cases where you can pretty safely determine that you don't need to worry about the HSR. For instance, office buildings and residences, hotels and motels, unless there's a ski facility involved, recreational lands, so golf courses, tennis clubs, that sort of thing, and farmland. Although that does come with the caveat that if there are processing facilities on or adjacent to the farmland at issue, then the exemption may not apply. This is an example of how the FTC has sort of narrowed the interpretation of some of these exemptions to account for what it perceives as potential competitive concerns. So it's always important to check with us to make sure that the exemption that seems to apply does. There are some other exemptions that apply to broader categories of transaction, like carbon-based mineral reserves, but that applies only up to a cap set at $500 million, subject to adjustment each year. And then there are some exemptions that require fairly detailed analysis. When you're looking at acquisition of voting securities of a foreign issuer or foreign assets, then we need to look at other factors that come into play there to see if the exemption actually applies. That would include the sales in or into the United States of the foreign issuer or the revenue generated by the foreign assets in or into the United States. So that's an exemption that may apply to a lot of transactions, but it's something that needs to be worked through very carefully before you can take confidence that you don't have an HSR obligation.
So, Michael, if we consult with you and determine an HSR filing is not required for a transaction, does that mean that it doesn't involve any antitrust risk?
No, it clearly can involve antitrust risks, and that's the antitrust laws are substantive laws. The HSR Act is a procedural law. As I said a few moments ago, the HSR Act involves just determining whether a transaction hits certain arbitrary number levels and whether it falls into one of the areas, the exemptions, where it's unlikely that there are anti-competitive effects. But the substantive antitrust laws will still apply. The Justice Department and the Federal Trade Commission can and do challenge non-reportable transactions. For example, about 4 years ago, maybe 5 years ago, the Justice Department challenged the Bazaar Voice acquisition of one of its smaller competitors. The Justice Department won at trial, and Bazaar Voice had to divest the assets at a fire sale price. And I think that it was that same year that the FTC challenged the St. Luke's acquisition of a practice group in Idaho. And again, the FTC won at trial. So these things do happen. But that actually reminds me of one other point, that we will often see in the press release, especially one prepared by investment bankers, a larger number than the deal value actually is. And that's because in the investment banking world, they like to talk about the enterprise value of a transaction, which is great. It makes this transaction look very big, and it is big. But from the HSR perspective, we are looking at the value of the voting securities that are being acquired, which may be a much smaller number. Now, the result of that is that on occasion, we will receive calls from the Federal Trade Commission pre-merger notification office if they have reason to know that Dorsey is associated with the transaction, which they might see in a press release about the deal. And if the press release makes it look like the transaction ought to have been reported, we will get a question of why it wasn't reported. And we like to be prepared with the answer so that we can nip that in the bud. Sometimes in-house counsel can also receive those calls, so it's good to have thought through and make sure that you can very quickly check that off the box.
So, Erik, if our analysis indicates that a transaction requires an HSR filing, what should the parties expect in terms of the process?
Sure. So the first thing you may be wondering is who's actually going to be filing this notification with the FTC and DOJ? And the answer is that it's the UPE, ultimate parent entity, of the buyer and the seller, which file notification. Now, in some cases, determining who the UPE is quite simple. In other cases, it requires a more complex analysis, and we often will work through that analysis as we're looking at the early analysis we discussed about whether the transaction is reportable. Essentially, the UPE is an entity that is not controlled by any other entity. Now, this means that it's an entity that no one holds more 50% or more of the voting securities, and or no one has the right to appoint 50% or more of the board of directors. For a non-corporate entity such as an LLC, it relates to no one has the right to 50% or more of the economic interests. The two important things with the UPE, one is, of course, making sure that you have the right UPE on your side of the transaction, which may not be the entity that's actually making the acquisition or which is being acquired. The other is that the filing is coming from the UPE, meaning that the search for information and documents that need to be provided as part of the HSR process may need to go up to that UPE level, and particularly if you've got a fragmented corporate structure, for example, a U.S. subsidiary is making an acquisition. When we look for documents and information, we've actually got to go to the parent company, which may be a non-U.S. company, may be completely different people involved. It's important to build that into the process, both in terms of timing and internal expectations. Some other basics on when HSR filing is required. There is a HSR filing fee. This is based on the size of the transaction. Now, the baseline is that the buyer pays a filing fee, but parties do and can choose to allocate the fee between them. Important point here being that the FTC has been increasingly strict about requiring that the filing fee be in and confirmed and not treating the parties as having filed notification until it has confirmed receipt of the filing fee. Once the filing is in and the agencies have confirmed that the filing fee is in, the parties need to observe a 30-day waiting period before closing the transaction. Now, there are some exceptions. There's a shorter waiting period in an all-cash tender offer. Additionally, the parties can request early termination of the period, of the waiting period, which is something we'll discuss a bit later. And Michael, additionally, parties can also think about, if they have a substantive issue, whether they really want to just put in a filing and then wait in the 30 days for the agencies to call.
Yeah, and that's something that requires some consideration, because if you have a high degree of confidence that the agencies are going to look at your transaction, then you may want to do something different from simply putting in your notification and waiting to see what happens. There are some industries in which I can predict with a pretty high degree of confidence that one agency or the other, and I can usually predict which one based on past practices, is going to look at the transaction. And in that case, you are sometimes better off going into the agency before you've even made your filing and starting to explain the transaction. And they can appreciate that, because particularly if the agencies are busy, it might take them time to staff up on an investigation. And if you give them an extra 2 weeks before you even file, or 3 weeks, whatever the number is, that gives them some time to start thinking about the transaction and who on their team they are going to need to look at it. Now, that's a particularly useful strategy if you are confident that the agencies will look at your transaction but can be pretty quickly persuaded that there isn't really a competitive issue to pursue here. So in essence, what you are doing is you are lengthening your waiting period by whatever amount of additional time you allow the agencies at the front end. So you convert your 30 days into maybe 7 weeks, whatever the number is. The other option is that you can decide, I'm going to wait and see if I get a call. And at that point, you have to figure out whether the agency really can finish their investigation within that initial 30-day waiting period. You will, toward the middle to end of that period, you might start getting some hints from the agency that, boy, if only they had more time, they could complete this investigation without having to issue a second request. And my practice, I think I've done this in all but one transaction. I've bitten and said, well, then we will withdraw our notification and promptly refile it. So I've now extended the waiting period from 30 days to 60 days. And again, the reason you would do that is that you are confident that you can get the transaction done with that additional time. If you think that that's not likely to happen, then you might decide instead just to go ahead and let the second request issue. And the second request basically it's the fairly burdensome request for additional information that the Justice Department or Federal Trade Commission will issue so they can gather more information about the transaction and decide whether they want to pursue it. The issuance of that request automatically extends the waiting period for an indefinite amount of time, which I think we'll get to in a later slide, but it's an indefinite amount of time up until the point where both sides have complied with the second request plus an additional 30 days.
So James, can you talk us through when the parties need to submit filing to the DOJ and FTC?
Yes, there's no statutory deadline as such, nothing that says that the parties have to file within 15 days of signing an agreement or anything like that. Instead, the timing works like this. You can't close until the 30-day waiting period expires or early termination is granted. So you really need to work backwards from that and figure out at what point you'll need to file in order to close on time. The parties can file based on a signed agreement, but they can also file based on a signed letter of intent or a memorandum of understanding if if they need to get a head start on the filing ahead of getting the definitive agreement signed. But that does have to be signed by both sides. Other transactions like tender offers may not have an agreement as such that you would have for a merger agreement or some other acquisition. And there are other rules that apply for when the filing can be made and the basis for it, but involves, at least in the case of tender offers, sending a letter of notice to the party whose shares are going to be acquired. So the best way to work through the timing issues for the HSR is to look at the targeted closing date and count back from that to figure out when you need to file or should file. It's a good time to take into account the possibility that the time for reviewing the HSR will go longer than the 30-day period, and leave room for that if you need to. A lot of times, purchase agreements specifically address HSR timing issues, sometimes with something as simple as filing as soon as practical, as soon as reasonably practical. But more often we see provisions that set a specific number of days, number of business days, usually 10, sometimes 15, and usually also with some provision to extend that upon agreement of the parties if something comes up that makes it advisable to delay the filings.
And if I could add to that, you'll see that absolute time period applied to the HSR notification. You won't see it, or at least will rarely see it, for non-US merger control filings. And the reason for that is that it's a lot more difficult to get those filings done because you have to submit drafts of your notification to the competition authorities in other jurisdictions, and they will review them, and you may have to submit more than one draft. So and I don't think I've ever seen a provision that says we will submit our draft notification within X number of days, although I suppose that's possible. But that's just a much more difficult process to allow absolute time periods for.
And just to follow up on the concept of filing on an LOI, in my experience, it seems much more common to file on the definitive agreement. What are the considerations that would make a party file on the LOI instead? Is it mainly timing, like you mentioned?
Yeah, it's basically you want to get the process started. It can have some psychological effects in the negotiation process, that parties are now more committed to the deal, particularly after that filing fee has been paid and you've taken another step toward getting to closing. But you also have to think about, is this a transaction where there is some substantive antitrust risk? Because if you file off the LOI, you have effectively allocated all of the antitrust risk to the seller. Because if the agency decides to investigate, you don't have anything binding upon the buyer to continue with the transaction. Now, if there's no substantive antitrust issue, who cares? But if there is at least some possibility of one, then you'd want to think twice about whether to file off that LOI.
So, Erik, it's not unusual for closing to be driven by the HSR process. Can you tell us more about the option to file for early termination and whether it accelerates the process for parties?
Absolutely. And we've referenced this briefly a couple times earlier. Parties can request early termination of the 30-day HSR waiting period. And essentially, it's likely to be granted if neither the FTC nor DOJ is really interested in looking further at the transaction. Now, there's no additional fee associated with requesting early termination, nor is there any penalty for requesting early termination if it's not granted. The one difference is that when early termination is granted, the name of the UPE on both sides, ultimate parent entity, as well as the name of the entity that's being acquired, will be published on the FTC website as well as in the Federal Register. And so that obviously has some key considerations. If your deal is not yet public and you request early termination and it's granted, you could have the grant of early termination be the public disclosure of the deal. So that's something that needs to be thought about. Early termination is pretty common. It's requested in about 3/4 of transactions, and when it's requested, it is usually granted. Overall, most transactions involve early termination being granted. In terms of the specific timing, we've seen it as early as 5 days in to the waiting period. We've also seen it as late as on the very last day of the waiting period that the grant of early termination comes in. Typically, we see it in the 2-week to 21 days range. And so parties do often want to know, when is early termination likely to be granted? When are we going to be able to proceed with closing? And that's what we say is, we usually see it in that range, but there are, of course, no guarantees when it will come in, and there's no guarantees that early termination is going to be granted at all.
All right, getting back to HSR, most lawyers say that they prefer to be called early on a matter versus late, and I'm sure you are no exception. Can you tell us why that's important for these purposes, Michael?
Sure, a number of reasons. First of all, I will say that I have completed an HSR notification in under 24 hours. I really don't recommend it and do not want to repeat it. Now, having said that, there are a lot of reasons besides my personal convenience why it's better to consult early on. The first is just to get a sense of what are the things that have to be accomplished before the transaction can close. And knowing whether the transaction is going to be reportable is very useful. You can build that into your deal time frame. It's also useful to know whether there's any chance of your being investigated because, number one, you might want to build that into your time frame, and second, you might want to build that into your consideration of what's a reasonable price for the transaction. You might also want to know, if you have an auction going on, you might want to know whether one buyer is more likely to create an antitrust risk than another buyer. I've been hanging around the M&A world for a long time and learned from our former, now retired partner, Bill Payne, that there are really only two important terms in a transaction: price and certainty. And knowing which one has antitrust risk goes into both of those, really. Another reason is that there is something on the notification form called item 4C and now item 4D as well. And those are requirements on the notification form that parties submit documents that they have created. Now, it doesn't require the creation of documents, unlike some of the non-US processes. In the US, the agencies require that you submit documents that meet 3 tests. They were prepared by or for officers or directors for purposes of evaluating this transaction with respect to competition, competitors, markets, market shares, efficiencies, or synergies. We like to get involved early on to help parties appropriately craft such 4C documents as they create. It is not helpful for the prospects of a transaction for someone to create a document, as happened in one of the very first deals that I worked on where there was an investigation, a document in which the buyer prepares pro formas that assume after the closing there will be a 5 to 10% price increase. This is just not something that I want to show to the agencies. You will also see documents that will talk about extremely high barriers to entry into a market. These are things which may mean one thing to buyers and bankers, but mean a different thing to the agencies, and we like to help people understand what it is that they might end up writing. Another thing that we like to do early on is advise on antitrust issues in the diligence process. Now, this is not really that important if the transaction is between, say, a PE firm that has no portfolio companies in the same space. It's just not likely to create antitrust issues. It's far more important where a direct competitor is buying one of its rivals. We had a case in the retail industry a number of years ago where the buyer was acquiring, it was a national chain buying a regional chain, and they literally had stores across the street from one another. Having information about SKU level pricing on a store-specific basis, not something you really want to be doing. So there are things that we should be advising on during that process. And then finally, we can assist with the drafting of provisions in the definitive agreement. James talked a bit about timing commitments. We have a self-interest in making sure that those timing commitments are something that we can live up to. And you also want to pay attention to the efforts clauses, which we'll talk about in a few moments.
So typically, we'll see HSR considerations come up in a few places in the agreement: pre-closing covenants, closing conditions, termination section. Can you walk us through some of those typical provisions and what you like to see there?
Sure. A typical purchase agreement, and again, when I say typical, I mean one that is likely to result in a reportable transaction and meets and might have some antitrust issues. But you want to figure out early on what are the efforts that the buyer is going to be required to undertake in order to get the deal closed. For example, if there is the example I just gave about the stores literally across the street from one another, you might want to see in that an advance commitment by the buyer that if it's necessary to get the deal closed, it will divest that store. And that's very common in the retail industry to have a divestiture commitment like that. Other examples are of divestiture requirements. You might require a divestiture up to a certain amount. You might define a divestiture commitment by reference to whether it will have a material adverse effect on the transaction or on the buyer's ability to use the assets that it's acquiring. And you want to pay attention to that in your closing conditions as well, because you want to make sure that the closing conditions take into account the buyer's commitments. You might also have some termination triggers. For example, you might want to have a termination fee or a reverse termination fee if the transaction fails to close based on antitrust grounds. And in that, what you're really doing is pricing the termination.
So is it fair to say that parties will typically take the perceived antitrust risk into account when they're negotiating these provisions?
Yes, with the caveat that sometimes they will have a provision that requires the buyer to take all necessary steps to close the deal, even though there really isn't an antitrust risk. So they're taking it into account, but the reaction is, I'm willing to make this very large commitment because I see zero risk. Now, you might not do that if you're a public company and it's a material contract, and that's going to end up attached to your SEC filings because now you've created a precedent that might be used against you in the next deal.
And just a couple examples of the way this can play out. So in the AT&T Time Warner deal last year, the parties had an outside termination date in their agreement that if the conditions were not met and if approvals had not been attained by a certain date, then the deal would terminate. Now, it was extendable by the parties, and in that case, parties did extend it several times and had extended it again, and 10 days before that date expired, they prevailed over the government in the challenge. Now, in that deal, it made business sense and legal sense in terms of the antitrust risk for the parties to mutually agree to extend that date, and it ended up working out. But it doesn't always work that way. So a few years ago in the Halliburton Baker Hughes proposed transaction, the parties' deal was being investigated by the government. The parties proposed certain divestitures. DOJ was not satisfied with those and ultimately filed a complaint to challenge the transaction. While that challenge was pending, the parties crossed over the date at which the parties could choose to no longer proceed with the transaction, and the seller chose to exercise that right, and that meant that Halliburton had to pay Baker Hughes a $3.5 billion termination fee, reverse termination fee, because the transaction hadn't closed due to the antitrust conditions. So these are just a couple examples of how this can play out, but again, it goes back into what Rachel was saying, which is that where there's a potential substantive antitrust risk and where there's a real prospect for a challenge, you do need to be thinking about, in the purchase agreement, how are we allocating that risk here?
Yeah, I think there's actually an even better example, and I'm blanking on the party names, but this was 2 or 3 years ago, and I want to say it was Electrolux, but what happened in that one was that the case went to trial. During the trial, the outside date occurred. The seller decided, I'm going to go ahead and exercise my right, I'm going to get my reverse breakup fee, and I'm going to sell the assets to someone who's actually going to pay me more money than my first buyer had agreed to pay.
Yeah, that was the Electrolux and GE deal, and that actually, so they went through 3 weeks of trial, and it was supposed to be a 4-week trial, and so they were heading into the last week of trial, and that's when they hit that date and ran into that termination.
And one footnote, this is not the way to make friends with a federal judge.
So transactional lawyers will often refer to the conclusion of the HSR process as HSR approval, but we're often corrected by our antitrust colleagues in saying that this is really a misnomer.
Coached.
Coached by our colleagues. James, could you tell us why that is?
That's right. There is no HSR approval. DOJ and FTC don't give the thumbs up on any transaction. They simply say, we do not object for now. The HSR process is an opportunity to present information about the transaction to the agencies, to allow them to review what they think is most likely to be pertinent to the competitive issues, and to determine, or at least give them the option to determine whether or not they want to object or to the transaction or investigate it, before it closes. The fact that they don't investigate or object to the transaction doesn't mean that there are no competition or antitrust issues involved in the transaction, and the agencies can certainly come back later and bring enforcement actions. If DOJ and FTC do object to the deal, you will know it. There will be an investigation that is quite onerous, but in order to actually stop the transaction from closing, the agencies would have to go to court and get an order to that effect, or work out a settlement with the parties to allow them to close under certain conditions. But DOJ and FTC can always challenge the transaction after it closes. They can even challenge transactions that weren't reportable in the first place, as Michael mentioned earlier. And of course, the HSR process is it only pertains to FTC and DOJ review. The antitrust laws can be enforced or litigated by private parties. So if there are individuals out there who believe that your transaction has imposed an antitrust injury on them that was somehow overlooked by DOJ or FTC, those individuals of their own accord can bring a lawsuit challenging the antitrust implications of the transaction. So the HSR process allows you to close, but does not guarantee that you are free and clear of antitrust issues at any point in the future.
And I don't want to say it happens often, but it did happen, I think it was late 2017, early 2018. And shortly thereafter, Barry Nigro, who was opposite him in a deal once, but he is one of the deputy assistant attorneys general for the antitrust division, was just talking about this case, and he said, this was an easy call. If we missed something during the review process, okay, we missed something, but if there are actual anti-competitive effects, that's an easy decision. We're going to challenge the transaction. Now, again, it doesn't happen often because they do use the process to filter out those transactions where there might actually be an issue. But if they have missed something, there will be a challenge.
So, Michael, what happens if the parties don't file on a reportable transaction?
Well, first of all, that's exactly why you want to get us in early. You want to make sure your purchase agreement has a contractual provision obligating the other side to file. So they have a statutory obligation. You want to convert that into your contractual right to force them to file. Although I've never had a deal. I've had deals where people will disagree whether something is reportable, but I've never had someone say, I'm not going to file on a reportable transaction. That would not be a wise thing to do. But there's a reason for that, and that's because there is a daily penalty for failure to file, or what amounts to the same thing, submitting an incomplete filing. So, for example, if your filing fails to include the 4C documents that we talked about that should have been included with your notification, that's treated as if you have not filed at all. That does happen from time to time. There was a classic case about 7 or 8 years ago where the filing party submitted a notification that said there were no 4C documents. This was certified by an officer of the company. The FTC called up the attorneys to say, are you sure there aren't any 4C documents? That attorney recontacted the client and then reconfirmed to the FTC that there were none. The FTC terminated the waiting period, and then shortly thereafter started a proceeding against the company because there were in fact such documents which they found out. They didn't terminate the waiting period. They issued a second request. They found documents that should have been submitted with the notification and weren't, and imposed civil penalties on the company and I believe on the certifying officer for failure to submit those documents.
So James, we talked earlier about some rules of thumb to determine whether a transaction is reportable. Where do you see parties most commonly making mistakes in this analysis?
Well, one of the most common, and I think that most years there's at least one or two of these, are corporate executives who, as part of their compensation generally, acquire voting securities or exercise options or warrants or acquire voting securities in some manner that results in the crossing of a reporting threshold. And in that case, sometimes it's overlooked that acquiring those securities has crossed the threshold, and that may result in pretty significant penalties for the executive that that didn't realize that. A recent example is the owner of the New York Knicks, James Dolan, who faced a fine of over $600,000 for failure to report the crossing of a threshold.
There is, by the way, a one free bite rule. The FTC and DOJ basically will not prosecute if they are convinced that number one, that it's the first violation by a person, that is a corporate entity and all of its included entities, and that it was inadvertent. But then the second one they will hammer.
Another example that you see where the agencies regularly bring enforcement actions is when the acquiring person fails to aggregate their existing holdings in the target and take that into account when filing. So, basic example, you have company A, they're acquiring, they already hold 40% of the shares of issuer. Then in a particular transaction, they're acquiring 20% more, which would put them over the control threshold, and they don't evaluate their filing obligation properly and don't realize that they need to file because they're only looking at the acquisition of the 20%. Another way that this can come into play, Michael mentioned earlier that if you have a non-voting security in an entity, but you're going to convert it into a voting security, you need to look at the potential reporting obligation, and you also need to look at aggregation with existing holdings. So a few years ago, Berkshire Hathaway had to pay a penalty because it had converted some notes into voting securities, but it had failed to aggregate its existing holdings in the issuer and look at when the conversion, as well as the aggregating the existing holdings, would have taken it over the notification threshold. And so that's, again, a common one where you see failure to file.
So, Michael, earlier you gave the example of 2 restaurant chains across the street. What additional considerations do you need to think through when the parties are current competitors?
Well, there are no formal differences in the rules, but the likelihood that that the transaction will be investigated will certainly increase if you have direct competitors who are parties to the transaction. You'll want to look at whether any of the documents that the FTC and DOJ are likely to see with that initial notification, those 4C and 4D documents, whether those have been well prepared and have avoided raising red flags. Another of the documents you'll want to look at in a public company deal is their 10K. There will often be a section in that on who what's the nature of competition in the industry, who the competitors are. And if I have a public company deal, one of the first things I do is look to that competition section to see if the counterparty is one of the identified competitors and whether there are additional identified competitors, because you're not going to run from a document that has been filed with the Securities and Exchange Commission. When you have a transaction involving competitors, that again, as I said earlier, puts a premium on avoiding inappropriate information sharing in the diligence process. You want to make sure that the kinds of information that are particularly competitively sensitive are not seen by people who could misuse that information. And my basic test is if you knew that your competitor, say there's no deal in the works, but if you knew your competitor was going to have access to certain information, could they use that to hurt you by competing more aggressively against you? And if the answer to that commercial question is yes, then the answer to the antitrust question of whether it's appropriate to share that information is no, because they could also use that information to compete less aggressively with you, which is where the antitrust problem arises.
So, James, if the parties determine an HSR filing is required, what happens after the filing is actually submitted?
Well, once you've gone through the thoroughly enjoyable process of preparing your HSR, that's what everyone wants to do right after they sign a deal is jump on the HSR. But once that's ready and out the door, you'll see that we send it to the FTC and DOJ, identical copies to each agency, and usually get file stamped copies by return messenger. And so the agencies each get their copy and they have a chance to review it. I think for both agencies, probably within about a week, they've done their initial review, and that's the period where we might hear back that early termination is granted, or we might get a call saying, hey, we have some questions about the transaction. Now, when one of the agencies, when there is an investigation, it's done by one of the agencies through a process that the agencies call clearance, not to be confused with clearance of the waiting period or the end of the process. But it means that one of the agencies has been cleared to investigate. It's a negotiation between the agencies. The FTC and DOJ each have their sort of fences staked around certain industries or technologies that they feel like they have expertise in and have claimed as theirs to investigate when things arise. Sometimes the agencies fight about it, and the parties can be caught in the middle, and we'll be fielding calls from the agencies jointly to help them decide who's going to be able to investigate or at least make the decision about investigating. Investigations can often be completed within a 30-day waiting period. If the agencies truly do just have questions, sometimes it's a matter of just going back and digging up some documents from what we call ordinary course documents. That means documents that weren't prepared specifically for the transaction, but to address concerns of that the agency has about the competitive dynamics of the companies involved in the transaction, or concerns about particular customers or markets or that sort of thing. And if that information can be found quickly and provided to the agencies, sometimes within well within the 30-day period, the agencies can end their investigation and allow the waiting period to expire or grant early termination. Sometimes it's a little bit more involved, and they may need to speak to one of the business people. As Michael mentioned earlier, the parties always do have the option of pulling and refiling. So if there is an investigation of some sort that has started up, and it doesn't look like it's going to be resolved within the first 30-day waiting period, the parties can choose, well, it's the acquiring party that really makes the decision, can choose to pull the notification, refile within 48 hours. There's no additional filing fee if it's done within 48 hours, but that restarts the clock another 30 days on the waiting period for the agency to resolve its investigation, hopefully, or determine that it's going to have to issue a second request, on which you would obviously hope not, hope wouldn't happen. But that does happen in a small number of transactions. When the second request is issued, that extends the waiting period until both parties have certified that they have substantially complied with the second request and an additional 30-day waiting period has passed. Now, the second request is not something that you want to get for obvious reasons. It's going to mess with your deal timing, but it is a very onerous process to work through. The requests are very extensive and require simply a lot of information about the company's business and its customers and the markets that it operates in. But that being said, it is possible to negotiate with the agency that issued the request to narrow those the request to what the agency needs or feels is most important, and it's usually possible that to negotiate that certain items don't need to be completed in full, or maybe some of them don't need to be completed at all. So there are ways to minimize the burden once you do get the second request, but even if you only have to respond to a couple of the items, it's a pretty involved process.
And both the FTC and the Justice Department have published on their websites model second requests, so it's easy to get a general sense of what they are going to look for in that second request. They've also both published model access letters, is what one agency calls them, and voluntary request letters is what the other calls them, so that, again, you can get a general sense of what they're going to look for in that initial informal investigation. And if you think that there is a chance that your transaction is going to be investigated, but you don't want to give up the chance that it won't be investigated, then a middle ground is to early on, even perhaps before you filed, start collecting the information that you know that the agencies would request should they decide to take an informal look at it. So you'll get a copy of your strategic plan, you'll prepare a list of your products, you'll identify overlaps with the other party's products, you'll put together a list of your competitors, and you'll put together a list of your top 10 customers, including contact information.
So how often are transactions investigated, Erik?
It's a good question. So first, what we have up here on the slide is just the total number of reported transactions by year. You can see there's a dip there in 2009, obviously associated with the recession, and then the number of reported transactions has been increasing every year. On the next slide, you'll see how many deals actually result in a second request. And you can see it's a relatively small number, between 2.5% and 4.5%. As James mentioned, if there is a second request, it's an owner's process, and the deal timeline is certainly, at the very least, going to be dragged significantly out, and so it's important to try to avoid it if possible. On the next slide, you see, though, that, and again, as James and Michael alluded to, one of the agencies may investigate a transaction and not actually get to the point of initiating a second request. In fact, for working on a deal, that's, of course, what we hope will happen if there's an investigation, that we won't get there. This chart shows by deal size how many deals actually had second requests, and also how many had one of the agencies cleared to investigate the transaction. You see the takeaway number there, 14%. So in 14% of transactions, either FTC or DOJ obtained clearance to actually go ahead and investigate the transaction. Now, in all these deals, there's not a challenge. Many of these deals may, in fact, have had the waiting period expire within 30 days. But the point is that for these deals, at least one of the agencies did want to take a more detailed look.
So, Michael, you mentioned there are a few scenarios if the government challenges a transaction. Can you walk us through what those are?
Sure. And it's important to remember that the process, it's not really a binary process. You can be pursuing multiple strategies at the same time. So you might decide in that initial 30-day waiting period that this transaction is going to require a divestiture. but you're not going to get a deal negotiated within that time. And frankly, the agency is unlikely to be willing and able to do that without having issued a second request and, kicked the tires and made sure that they have identified all of the significant competitive issues. But you might go into it with a negotiation strategy in mind, even though you're going to get the second request. And then when you get the second request, you will negotiate and try to focus the agency on the important issues first, and maybe ignore other things that they could investigate, but really are not likely to make a difference to the ultimate remedy. And so you try to channel the investigation in order both to speed up the process and reduce your costs. If you decide to go to litigation, though, one possibility is that the government tries its case, and remember, it's not an HSR approval process. They do have to go to court to get an order shutting down your deal. The government could lose on that preliminary injunction. The chances are that you will then proceed with your transaction unless the government decides to appeal, and then you're going to have a negotiation over whether you will hold off closing your transaction pending that appeal, or maybe close the transaction but hold the assets separate and operate them independent of the buyer. We had one deal, this was actually a consent. It started as litigation, but then had a settlement. And between the time that the settlement was approved and the assets were finally divested, I think it was like a 2-year period. So it can go on. That was quite unusual, though. Another option is that the government wins on the preliminary injunction, and the chances are that the parties are then going to just abandon the deal. Now, they're not required to. They could appeal themselves. But if you've gotten that far, you've probably gotten pretty darn close to your outside termination date, and the economics of the deal may well have changed. So if that happens, you're probably going to abandon the deal. And at any point in the process, you could have made that decision. So the moment that second request is issued, you could decide the expense of complying with the second request, the time it's going to take us to do that, and the uncertainty of that process makes it just not worth it. We're just going to abandon our deal right now. But you could also make the decision, we're going to fight this. We'll do it cooperatively. We're not going to waste anyone's time or resources, but we'll get it done professionally, and we're going to close our deal. Obviously, you have to keep winning for that to happen.
So we often hear concerns about gun jumping in the M&A world, especially as the parties begin thinking about integration and possible synergies. James, can you give us an overview of the issues that parties should keep in mind on this front?
A quick overview?
Yes, a quick overview. So we are well aware that before the HSR has been filed and while the waiting period is running, there are other things going on in the deal. There may be continuing diligence, there's integration planning, and the parties need to be very careful with this, that they don't, first of all, violate the HSR Act by acquiring operational control of another company before the waiting period has ended. That could be implicated by requiring approval for non-material contracts, making business presentations to customers that imply that the companies have already become that the transaction has already occurred and the companies are acting as one. Joint sales calls, allocation of customers, pricing decisions. Those are all very serious issues that need to be avoided. Notwithstanding the assumption that the transaction will go through and the need to start coordinating and planning. Integration planning and diligence can all happen within the confines of the HSR and antitrust restrictions, and we are always happy to help out with that process. Just really quick, the other substantive antitrust laws apply all the time up until closing. So agreements on price, that sort of thing are always, antitrust violations and should be treated warily.
These are just some examples of gun jumping penalties. The penalties here are really a function of how long the violation goes on because they're assessed per day, as well as, what is the extent of the violation? Has the buyer taken over, full control of the target, or is it a more sort of isolated gun jumping violation?
And it's also a function of the dollar amount of the maximum daily penalty. For those early ones, the maximum penalty was, I believe, still $10,000. So those would be much higher today, adjusting for that.
Well, I think we're just about out of time. But our panelists are happy to answer any questions that you submit via email to dorseyu@dorsey.com. And thank you all for attending today.
Thank you.